Judgment in the matter of Crown against Layden.
Lord Hamlin will hand down this judgment.
When an appeal against conviction is allowed, the Court of Appeal may order a retrial under Section 7.1 of the Criminal Appeal Act 1968, which I will call the 1968 Act. It may do so if it appears to the Court that the interests of justice so require. Section 8 of the 1968 Act sets out supplementary provisions for retrials, including that the defendant shall be arraigned within 2 months from the date of the order for retrial. Arraignment is a court process which involves identifying the defendant, reading the indictment to the defendant, asking the defendant to plead guilty or not guilty, and recording the plea. A procedure is then provided under Section 8, whereby the prosecution can apply to the Court of Appeal for permission to arraign outside of the 2-month period, and the defence may apply to set aside the order for retrial. In the present case, the retrial took place without the respondent being arraigned within 2 months of the order for retrial, or at all. No application to the Court of Appeal was made under Section 8 by either the prosecution or the defence. The respondent successfully appealed against his conviction on the grounds that in these circumstances the Crown Court had no jurisdiction to try him. By way of factual and procedural background, on the 19th of March 2015, the Court of Appeal quashed the respondent's conviction for murder and ordered a retrial under Section 7.1 of the 1968 Act. The respondent was not arraigned within 2 months of the order. On the 17th of May 2016, the respondent was convicted of murder following a retrial. He was sentenced to life imprisonment with a minimum term of 8 years and 359 days. On the 11th of February 2022, the Court of Appeal handed down its decision in Llewellyn, quashing the defendant's conviction in that case on the basis that the failure to arraign within 2 months had resulted in the total invalidity of the retrial proceedings. This led to the respondent's case being referred to the Court of Appeal by the Criminal Cases Review Commission. On the 25th of October 2023, the Court of Appeal gave judgment allowing the respondent's appeal. Following Llewellyn, the Court of Appeal quashed the respondent's conviction. The prosecution now appeals to the Supreme Court against the decision of the Court of Appeal. In its judgment, the Supreme Court unanimously allows the prosecution's appeal and overrules the Court of Appeal decision in Llewellyn. I give the judgment with which the other justices agree. The principal reasons for the judgment are as follows. The general power to order a retrial was introduced in England and Wales by amendments made to Section 7 of the 1968 Act by the Criminal Justice Act 1988. The legislative history shows that the general power to order a retrial was born out of concern that otherwise the process of the criminal law itself is brought into disrepute when an apparently guilty man has to be freed on a technicality. That was the mischief being addressed. There have been a number of authorities concerning the Court of Appeal's power under Section 8 of the 1968 Act to grant leave to arraign outside the 2-month period. These authorities were reviewed in the judgment and revised guidance provided, having regard in particular to the purpose of Section 8, which is to ensure that the retrial proceedings are brought under judicial control and that the retrial takes place as soon as reasonably practicable. As to the wording of Sections 7 and 8, in both Llewellyn and in this case, the Court of Appeal interpreted the Crown Court's jurisdiction to conduct a retrial as being, quote, contingent on the requirements of Section 8 being complied with. The question of when and how the jurisdiction of the Crown Court ceases raises obvious difficulties with this interpretation. Further, Section 8 expressly sets out the circumstances in which the Crown Court is deprived of its jurisdiction to conduct a retrial. Those are where an order is made setting aside the order for retrial and directing the entry of a judgment and order for acquittal under Sections 8, 1b(b). As a matter of wording, it is therefore difficult to see how Section 8 is at the same time implicitly providing that the Crown Court is deprived of jurisdiction where there is a failure to comply with the procedural requirements of Section 8, as is reinforced by the conceptual and practical difficulties which otherwise arise. Section 8 does not express what the consequence of failure to arraign within the 2-month period limit should be. The principle in Synergy, a House of Lords decision in 2005, applies. That principle is that where Parliament casts its commands in imperative form, without expressly spelling out the consequences of a failure to comply, a flexible approach is required, and the emphasis ought to be on the consequences of non-compliance and posing the question whether Parliament can fairly be taken to have intended total invalidity to follow from non-compliance with the statutory requirement. In order to consider whether Parliament can fairly have intended total invalidity to follow, it is necessary to identify the alternative total invalidity. In the present case, that alternative is an appeal against conviction on the ground that had an application been made under Section 8 before the retrial, leave to arraign would have been refused and the order for retrial set aside. A conviction is obviously unsafe if it results from a retrial that should never have taken place. The recognition that this is the alternative to total invalidity undermines the foundational reasoning of the Court of Appeal in Llewellyn and in this case. The Section 8 procedure would not be avoided or neutered. A decision would be made by reference to the Section 8 criteria and by the Court of Appeal. The defendant's Section 8 protections would not be lost. If this is the relevant alternative, it is difficult to discern any good reason why Parliament should have intended total invalidity. This becomes even clearer when one considers the consequences of total invalidity, namely, 1. Total invalidity may arise irrespective of whether the object and purpose of Section 8 has been met. 2. Total invalidity results in the perverse incentive for the defendant to do nothing and refrain from exercising the right to apply to set aside the order for retrial. 3. Total invalidity results in a perverse incentive to abscond and thereby avoid being arraigned. 4. Total invalidity means that a conviction will be set aside for a failure to comply with the Section 8 procedural requirements, even where it is clear beyond peradventure that leave to arraign would have been given had the requisite application been made. 5. Total invalidity leads to the anomaly that whilst a failure to arraign at all will not affect the validity of a trial, a failure to arraign timorously will render a retrial invalid. 6. Total invalidity may read across to double jeopardy. 7thly, total invalidity undermines the purpose of Section 7 and risks bringing the criminal justice system into disrepute. In a case where there has been a retrial as soon as possible, a retrial which is conducted fairly, a conviction which is otherwise safe, and the guilt of the defendant is not in doubt, the conviction will nevertheless be set aside on a technicality, even in the most serious of cases. For all these reasons, the Supreme Court allows the prosecution's appeal and overrules the Court of Appeal decision in Llewellyn.
The court will now adjourn.